So some people will see that as an opportunity to get a lot of assets out of their personal estate and get it into this entity so that when it does come time in which they die, then they will not be looking at estate taxes. Now there's a lot of uncertainty now about what in fact will be the rules after 2010. We know that in 2010, under the present sunset laws, the estate tax will be gone entirely during the year 2010. Then 2011, as it sits today, and this will probably be modified by Congress, but as it exists today, 2011 we go back to the more primitive levels of exemptions and taxation that we had in 2001. So I'll come to this subject and I'll talk a lot more about it later, but I wanted to introduce you to some concepts here that are also very helpful in understanding this trust discussion. So it can be a wonderful device, an irrevocable trust can be a wonderful device to get assets out of your estate by way of using these annual gift tax exemptions. And in this way, assets that you've transferred may actually appreciate and be worth a great deal of money by the time you die, and none of that will be brought into your estate. So if you can imagine the amount of money that per year you're getting transferred, and the amount that you might get transferred over a 10, 15, 20, 30-year period, then also contemplate the sort of appreciation that occurs in a lot of assets over that period of time, whether it's ownership interest in a small business, which could go up at a hugely precipitous rate, or it could be real estate, investment real estate, that also might appreciate very rapidly. This can be a powerful tool for minimizing the amount of taxes that will be paid out of your estate. And it avoids essentially what all too many people face, is their children end up with nothing after their death, because when the children inherit the assets, they find that they're having to pay the IRS 35, in some cases more, % interest on these, or excuse me, a % tax. They're finding that they're having to pay the IRS 35% of the value of these assets. Well, if they don't have the sort of liquidity, if there's not cash lying around to write the IRS a check, I mean, the IRS expects within this 9-month period or so that they're going to get a check for the value of the taxes, then that forces a sale of those assets. And those assets are often sold under liquidation circumstances, and a small business might yield 25 cents on the dollar being sold under those conditions, where assets such as that notoriously have to be really shopped and very carefully transferred in order to get the true value out of it. Similarly with respect to real estate. So irrevocable trusts can be critical when it comes to gift and estate tax planning, hugely important. And I want to mention one other thing on the tax side, and we'll come back to this, and I don't want to bury you with this detail at this point. I just want to give you enough to show you how trusts can be very important. Going back to income taxes for a minute. Because the income tax system or regime is not fully coordinated with the regime relating to the tax regime relating to federal estate and gift tax, because the rules are a little different, you can actually have a trust that fails to qualify as a transfer for tax purposes from the income tax purposes. In other words, when they look at those factors we were talking about a while ago, release of dominion and control, is this a real transfer, or is this sort of a flimsy sham of a transfer? And by sham, I don't mean that it's illegal, I just mean that it's not meaningful. And as a result, if the court concludes that, then they'll go ahead and tax you individually. Maybe an easier example is, what if you tried to transfer your assets to your children, and you wanted to continue controlling those and managing them to generate income, etc. So really all this has been is a sort of trick in order for you to minimize the tax rates of the income that's coming on that by having it ran through your children's tax rates, which, as you might imagine, if they're minors and earning no other income, would be very, very low compared to yours. So these loopholes, incidentally, have been closed a long time ago. But I want to make you familiar with this idea that if you, on a purely fictional level, transfer assets and still keep control of them, the IRS routinely says, no, we're going to treat you as the owner still, and we're going to tax it at your rate. In fact, that is precisely the rule with respect to assets that are transferred to children under age 18. So with that in mind, when you transfer an asset to an irrevocable trust, if it fails to be fully independent and fully separate, then you can imagine the IRS will do the same thing. Incidentally, it might turn out that that's actually helpful to you because for reasons I mentioned a few moments ago, you may find that your income taxes are actually lower keeping it in your name as opposed to the tax rates that will apply to this irrevocable trust. So oddly enough, it's possible for you to do this transfer in a way that fails to be a completed transfer for purposes of income tax. So the IRS continues to say, no, you personally continue to be liable for these assets. So whatever income comes into this trust, that's fine. It can be in this trust, but as far as we're concerned, we meaning the IRS, any income is taxed to you. So if the assets earn $1 million in that trust, it's on your return as an individual. You pay taxes just as if you'd kept it in your name. Well, you can manage to accomplish that, and at the same time, shifting regimes here. I mentioned the income tax regime is separate from that for estate and gift taxes. You can accomplish that and at the same time succeed in getting these assets transferred in a way that meets the criteria for estate and gift taxes. So for purposes of estate and gift taxes, the IRS is saying as to that same transaction, yes, this is a completed transfer. No, this will not be in your estate when you die. All those benefits I mentioned to you a while ago, the appreciation that is captured inside the trust, outside you personally, and as a result, your personal estate, you capture that benefit. Whatever other things might accumulate over that period of time in this entity are also going to be outside your personal estate. So we'll go forward with this series. And at the end of it, I want you to have a feel for what your asset protection plan might look like and the sort of components that you think would be useful to you. This equips you to go and see your attorney and to talk to him or her about what you want and to fully comprehend what's being said, to be a participant in that conversation, even a participant in the planning process in a way that somebody just coming off the street, I mean, you're entirely passive clay in the hands of your lawyer, and I assure you, you will get an asset protection plan at the end of the day, assuming this is what they do. But it's going to be a plan that they thought was best for you, or it was their plan and not your plan, because you were not really capable of participating as fully as you would like. Now, some would argue, no. I feel that if a client comes in and says to me, you know, I have children, I want to protect them, I have my wife, I want to provide for her, and just gives them these sorts of core components that the attorney can build from there something that meets their needs. Maybe. But I would argue you can definitely obtain a much better plan, and a plan that much better represents your ideas if you understand what those are. And I would go further than that. I would say that sometimes the ideas that you'll stimulate the discussion by saying, why can't we do this? Or tell me why a corporation is not permissible here. Now again, you're not supposed to be the expert on it, but what you've stimulated is the expert thinking about it and having to deal with your question. And it may in fact turn out that that is workable when it would never have been considered before. So there's no way in which you can but benefit by becoming very informed as a client. I mean, you need to captain the ship. And I would argue this sort of speech I give to divorce clients as well. We're at seminars. You know, I make clear to clients that look, you're the captain of the ship, and you have technicians and others involved. You have professionals involved around you, you know, who are working at your behest, and whose skill and knowledge, you know, you depend on, but who are not the substitutes for your judgment about the direction in which this ship is to go, and when and how it's to get into harbor, and particularly the harbor to which it's to arrive. I mean, you have to play that role, and it's not something that you should surrender to your divorce lawyer or your asset protection lawyer. You've got to continue to play that role, and in order for you to play that role, you have to understand something about it. So if you continue watching this series, I assure you, you'll know more than most lawyers about asset protection. Not most asset protection lawyers, but you'll know more than most lawyers about asset protection. Well, with that, we'll conclude this episode of Cash Counsel. My name's Joe Cordell, and we'll continue the discussion of asset protection. And I hope that you find this wonderfully informative, if not interesting, hopefully both. And over time, we'll take your questions on this topic. So we'll try to make this a dialogue eventually. But for the time being, I want to dump a lot of information on you, and I look forward to your joining me in the next several weeks. Take care.